Right, I call us to order. We are reconvening the March 9th Judiciary Finance and Civil Law Committee. Welcome members, and thank you everybody for getting through a bunch of bills this morning. We've got three more this evening, and gonna also try to catch some daylight still today. So we will get right to it. First up, we have a bill from Representative Frederick. It is House File 1432. The committee, it is here before us in this committee regarding Section 7, which is relating to data. So we're going to keep our focus and our discussion to that section. Welcome to the committee, Representative Frederick. I will move that House File 1432 be recommended to be placed on the general register. I understand that you have an author's amendment, Representative Frederick, is that correct?
It is.
Okay, I will move the A21-0075 author's amendment to get the bill in the shape that the author desires. Any discussion to the amendment? All those in favor, please say aye.
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 Opposed? All right, the motion prevails. The amendment is adopted. Thank you, members other than Representative Feist for voting. So the bill as amended is now before us. Representative Frederick, please tell us about your bill.
Thank you, Madam Chair, members. So the Vulnerable Adult Act was created our county-based adult protection system in Minnesota about 40 years ago. Similar to the child protection, adult protection teams respond to reports of abuse, neglect, or financial exploitation against vulnerable adults who live in the community, not in long-term care facilities. Unfortunately, in many of these cases, the perpetrators are family members and loved ones, including adult children, grandchildren, trusted caregivers, and other relatives. A lot has changed in the field of practice over 40 years, and although the Vulnerable Adult Act has gone through several changes, DHS is leading a redesign to update and modernize the law. County adult protection units have a dual role. They both, one, provide social services to vulnerable adults, and two, investigate claims of maltreatment to help keep the vulnerable adults safe. These investigations sometimes aid law enforcement if criminal conduct is uncovered. This bill is before your committee because DHS is proposing some changes to data classification and data sharing in the Vulnerable Adult Act. Currently, the law does not account for the two distinct roles, social service provider and investigator, and treats all data collected by Adult Protection Service as private data. And this is problematic because data related to the investigation should be a higher classification as confidential data, similar to that in child protection investigations. Since investigative data in the welfare system is already confidential per Chapter 13, the changes in Section 7 of this bill makes it simple yet important fix. This fix aligns the classification of investigative data of county maltreatment investigations with the classification of other investigative data in current law. This change will provide much needed clarity and will make it much easier for counties to protect the maltreatment investigation process until findings can be made and the investigation is completed. At this point, I would like to turn it over to DHS with your permission, Madam Chair.
All right, thank you, Representative Frederick. I'm not sure who from DHS was planning to testify, so if you want to just introduce yourself for the record and please go ahead with your testimony.
Madam Chair, Dan Pollock, Assistant Commissioner for Continuing Care for Older Adults at DHS. Really appreciate the committee's time. I don't have a lot to add other than to say that we really do see a significant need for this, and especially coming out of the pandemic and COVID, people who live in the community and are vulnerable adults need a vulnerable adult system, adult protection system that is a little bit more functional and is a little bit more of a 21st century approach. And so we think that this begins to address some of the needs of the system. And in particular, I think this reflects a really broad-based stakeholder engagement process that has talked to counties, has talked to law enforcement, has talked to people on the ground that are really on the front lines of adult protection and gotten their ideas for improvement, and begins to make progress in that direction. So I'm happy to take questions, or I can defer to the committee.
All right, thank you, Assistant Commissioner. Looks like we do have some member questions. Representative Scott.
Thank you, Madam Chair. And to the bill's author, are there any entities that are opposed to this new language? I know I believe stakeholders have been meeting for, regarding kind of reforming this area of law. And so I'm just wondering if there are any stakeholders that are not okay with this change.
Representative Frederick.
Madam Chair, Representative Scott, that's an excellent question. Everyone that I've talked to has been supportive of the language. I know DHS, and I will give credit where credit is due, has done the bulk, massive bulk of heavy lifting on this. And that they have reached out to countless people, and there is no one that I'm aware of that is currently opposing the language change.
Any follow-up, Representative Scott?
Nope, thank you.
All right, thank you. Any further member discussion to the bill? All right, seeing none, we will give you the last word, Representative Frederick.
Thank you, Madam Chair. There's a lot going on here. It's an incredibly impactful thing when we're talking about the Vulnerable Adult Act. It is a very important piece of legislation, and I was hesitant to take it on because I knew how big of a deal it is. And so I think to Representative Scott in the question of like, what other feedback are we getting? I think that DHS has done a fantastic job of reaching out to just lots and lots and lots and lots of stakeholders. And I want to give a shout out to Nicole Stockert from DHS for doing a lot of the work there. She's fantastic to work with and done great work with this bill. So thank you for hearing it, and thank you to members.
All right, thank you, Representative Frederick. With that, I will renew my motion that House File 1432 as amended be recommended to be placed on the general register. The clerk will take the roll.
Chair Becker Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
Aye.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell excused. Representative Hur.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
Aye.
Representative Liebling excused. Representative Long. Representative Long. Representative Mortensen.
Aye.
Representative Devotny.
Devani, aye.
Representative Farr.
Aye.
Representative Robbins.
Aye.
Representative Vang.
Aye.
Representative Zhang.
Aye.
And Representative Long.
Aye.
There's 15 ayes and no nays.
All right, the motion prevails and the bill is on its way to the general register. Thank you, Representative Frederick, and hope it wasn't too bad for your first time in the Judiciary Committee. With that, we'll get moving right on to the next bill. The next bill on our agenda is House File 1287. This is a Representative Hollins bill. Representative Hollins, would you like to move your bill to be recommended to be re-referred to the Human Services Policy and Finance Committee?
Thank you, Madam Chair. Yes, that is my motion.
All right, great. We have the bill before us, and it's my understanding you also have an author's amendment. Would you like to move the A2 author's amendment?
Yes, please. I would like to move the author's amendment.
All right, the A2 amendment is in front of us to get the bill in the shape that the author would like. Any discussion to the amendment? All right, all those in favor, please say aye.
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 Opposed? All right, the motion prevails and the amendment is adopted. Representative Hollins, please tell us about your bill as amended.
Thank you so much, Madam Chair, and thank you, committee members, for hearing this important bill. So the main purposes of this bill are to bring Minnesota's foster care licensing standards more in line with our adoption standards, to remove unnecessary barriers that exist in current law for relatives in communities of color seeking foster care licenses, and to ensure the well-being and stability of children. Under our current law, our foster care licensing standards and processes create many more barriers for individuals, including relatives, than even our adoption standards. This inconsistency creates problems for placing children in permanent safe homes, and it isn't good for family preservation or child well-being. This bill also brings Minnesota in line with current federal policy and recommendations relating to foster care licensing and background checks. It's really time for Minnesota to rethink the way that we license foster care providers. Unlike other providers requiring a DHS license, family foster homes are not a business, and they should be a safe haven for children who can't live at home. For communities of color, the statutory barriers in our current foster care licensing statute have an even greater impact, and this law would help remedy that disparity. When children can remain with relatives in foster care and stay connected to their families, they have better long term outcomes, including higher high school graduation rates, decreased risk of mental health disorders, and less overall trauma. This bill is especially important because COVID-19 has made family visitation for children within the child welfare system really difficult. Increasing access for relatives to obtain foster care licenses during this time will make it easier for children to both remain close with family, but also see family more often and consistently while they're in the system and out of their homes. Finally, I'd like to say that this bill is supported by many constituents across a breadth of experience and perspectives. It provides a really well thought out and very well negotiated balance to ensure the safety of children and also a more reasonable list of barriers that don't exclude many wonderful foster care providers who have an imperfect past. And I do have two testifiers here with me today.
All right. We do have another amendment that's filed, but we're going to get to the testifiers first, and then we'll discuss that amendment. So first on the list, I have Alexis Oberdorfer. If you could unmute yourself and introduce yourself and go ahead with your testimony.
Thank you, Chair Becker-Finn and members of the committee. My name is Alexis Oberdorfer, and I'm the president of Children's Home Society of Minnesota, and I'm the associate vice president for Lutheran Social Service. I represent two of the longest standing foster care and adoption programs in Minnesota, and we both date back to the late 1800s. I personally have over 25 years of professional experience in child welfare. And in a given year, my adoption team is involved in over 200 foster care and adoption placements throughout the state. Regardless of which door a family enters, there should be parity in the criteria that's used for foster care and adoption background studies. In 2018, we partnered with a local metropolitan county to assist kinship caregivers that needed to be licensed. And we took a look at kin that were identified to have a relationship with a child, a Black child in particular, who had entered foster care. In that year, we served over 34 families, but approximately 25% of them needed licensing variances. We witnessed how the foster care licensing criteria can create barriers for the BIPOC community. And when we looked at this and kind of recalling some of the cases that we looked at, there were two that stood out to me. So the first, I'm just going to call her Aunt Addie. She had a background study charge that popped up from 15 years earlier based off of a check fraud for which she had paid restitution. We supported her in seeking a licensing variance that was granted. She became licensed. She was an amazing resource for her niece and her nephew. And she really provided continuity to her family and mitigated trauma that these children could have experienced if they were cared for by somebody else who was not a family member or not familiar to them. They were reunified ultimately with their father. The second case is Grandma Joy, and she had lost her daughter right before we worked with her to an opioid overdose. She was dealing with significant grief and loss at the time. She wanted to care for her 5-year-old granddaughter, but she endured a series of obstacles to become foster care licensed. One of the barriers that she encountered was the background check process, and that she had a 12-year-old charge from an economic assistance fraud that had nothing to do with her ability to care for her granddaughter. Again, we sought a variance. We were successful at achieving that. Grandma Joy became licensed in fall of 2018, and then she did go on to adopt her granddaughter in the spring of 2019. When I sit and talk with my management team about non-relative foster care and adoptive families that we serve, they would tell me that less than 5% of our clients typically seek variances, and it really does demonstrate the disparities that are faced by BIPOC communities. We also know that research about relative and kinship caregivers demonstrate that they are some of the most stable placements and promote resilience for kids when they can be cared for in a setting with somebody that's very familiar with them. So based on all of this information and what our experiences are, I would testify on behalf and support of this bill, and I would urge this to be passed in this committee. And I thank you for your time today.
Thank you for your testimony. Next on the list is Max Page from the Hennepin County Attorney's Office. Please introduce yourself for the record and go ahead with your testimony. Oh, Max, you're muted. You were unmuted, but we still couldn't hear you.
Can you hear me now, Chair Becker-Finn?
Yes, I can. Please introduce yourself and then go ahead with your testimony.
Thank you, Chair Becker-Finn, and good evening, committee members. My name is Max Page, and I am an assistant county attorney in the Hennepin County Attorney's Office. I am the legislative liaison for the office, but when I'm not doing legislative work, I'm a trial attorney in our Child Protection Division. Last night, the committee heard a bill about the decision about whether to remove a child from their parents or not. Tonight's bill is about what happens after that decision has been made by a judge when a child is removed from their parent. When that happens, we do want children to be in the best home possible. Currently, Minnesota's foster care licensing system prevents children from being in their ideal homes. We have a preference in law that's been explained that when children can't be in the care of their parents, that they should be in the home with a relative, a home that's familiar to them rather than go to a stranger's home. We know that because children, and we see this in the courtroom, children do better when they're placed with their relatives. Unfortunately, there are times when decades-old criminal convictions or even charges will prevent relatives from being licensed for foster care. This is true even if that individual has been rehabilitated, if they're productive members of society, or if those exact same crimes would not prevent the child from being adopted by that individual if parental rights were terminated. We also know that the criminal justice system has a disproportionate effect on communities of color, and we know that the child protection system has a disproportionate impact on communities of color, thus compounding the issue when it comes to relative placement. That's why I want to thank Representative Hollins for authoring this bill, House File 1287. In short, as has been explained, it aligns the adoption and foster care licensing standards a little more close, or much more closely actually. It makes sure that past criminal history is considered when deciding whether to license a foster home, but it's not necessarily determinative of whether someone could be licensed for foster care. It makes sure that if someone does have a criminal history, that they have been rehabilitated, that they are now employed or involved in their community or church, and that they've received any services or treatment that's been needed. It requires, rather than just looking at someone and a conviction on a piece of paper, that the social worker goes into the home, that they observe whether this individual can actually provide care for a child. The bill is the result of a many years long negotiating process, and we've wound up in a really good place. It's got a wide group of supporters, and so I would encourage you to support the legislation. I'm happy to answer any questions the committee may have, but thank you for having me this evening.
Right. Thank you, Mr. Page. And that is it for testifiers. I do know we have quite a few people on hand from DHS with questions, but I do want to get to the A3 amendment first. I believe that's a Representative Scott amendment. Representative Scott, do you want to move your amendment?
Madam Chair, if I could just speak to it first, is that all right?
Yeah, please go ahead. Yep, please go ahead, Representative Scott.
Thank you, Madam Chair. And this is, my attempt to address the seriousness of the information that's contained within these background checks. It's really sensitive information, as you know, and my concern was that when it's being shared with other government entities, that audit trails and so forth were created so that there were protections and people could go back and find out who their information has been shared with, that sort of thing. And I spoke with DHS last night, and I believe Autumn is on the call. Did I see Autumn is on the call? Anyway, it sounded like adding this language was going to add a significant fiscal note to the bill. And there were some other issues because the FBI and the federal government are involved with these background checks that sort of made it unworkable. So I don't know if somebody, yeah, there's Autumn. If Autumn wants to address some of those issues that we came up with so that committee members could better understand. I'm going to withdraw the amendment, but I want her to kind of articulate why it doesn't work with this particular bill. If that's okay, Madam Chair.
Okay. Yep. No, that sounds great. I'm glad that you were making some phone calls and having those conversations. That's really helpful to know who to call on. So is it Autumn or Ms. Modi that wants to take that answer?
I will actually take that, Madam Chair.
Okay. Yep. Please introduce yourself for the record and then go ahead.
Thank you, Madam Chair, Representative Scott. My name is Kulani Moti, and I serve as the Inspector General at the Department of Human Services. And this is a little background within the Office of Inspector General. One of the divisions is our background studies area. And so wanted to share just some of DHS's concerns that we had about this. And do want to note that we appreciate and thank Representative Scott for continuing to work with us on this amendment. It is overly broad and would apply to all of our studies, and it would be very costly to implement. But understanding that this is sensitive information and wanting to know what we already what we currently do in order to protect the data privacy of these study subjects. So currently, all of the background study information that is through our Net Study 2 system, it's the system that houses all of this, is limited to business needs, even within the agency. So staff that have business needs must request the access, and then access is restricted to specifically what work that they are on. And all staff that do access our Net Study 2 system are required to take specific training that specifically addresses background studies data, criminal history information, and FBI data. These restrictions do comply with all of our requirements under the Minnesota Government Data Practice Act, as well as our federal laws for compliance with the FBI. And then just to let you know that the DHS is audited every 3 years by the FBI to ensure that we're in compliance with their data protection and privacy laws, and that we have and know who is accessing our system when we do send out systems, who it's going to, why, and what authority we have to share that information. So I just wanted to provide a little bit more information about what our current practices are. Thank you.
All right, thank you. That is unique to some of these issues that have come up in similar bills. Any follow-up, Representative Scott?
Thank you, Madam Chair, and thank you for that explanation, Ms. Modi. I guess I just wanted to again draw attention to the importance of keeping the data safe, and it sounds like there's at least policies in place to make that happen. And I had another thought, but it's escaped me now. It's been too long of a day, but thank you, Madam Chair, and I will withdraw the A3 and look forward to working with DHS in the future. Oh, I know what I was going to say. It came back to me after I was sharing with Autumn and Ms. Sommerfeld last night on a call that several years ago, I asked for a similar language for some data sharing for indigent people. And it's like, just because they're indigent doesn't mean that their data shouldn't be protected. So I said, can you please create an audit trail? And this was probably 8 years ago. And DHS got back to me with a $200 million fiscal note to create an audit trail. I'd never seen anything like it in my life. So what I told them last night is, with this budget surplus, and if the federal government's going to be sending money to Minnesota, then let's update some of these archaic systems, particularly in DHS. And thank you, Madam Chair. And again, I'll withdraw the case.
Thank you, Representative Scott. And with that, we'll go to committee discussion to the underlying bill. Members, are there any questions for the bill author or the testifiers? All right. Seeing none, Representative Hollins, any closing words about your bill?
Thank you, Madam Chair, and thank you, committee members. I would just encourage all of you to support this. This has been a project that has been worked on since long before I came to the legislature, and it would be really great to see this finally go into effect this year. I want to thank the testifiers for being here and the numerous people who've been working on this for the past 4 years, I want to say, and Chair Rena Moran for carrying this previously. I would encourage a yes vote, and with that, I would like to renew my motion.
All right. Representative Hollins renews her motion that House File 1287 as amended be recommended to be re-referred to the Human Services, Finance, and Policy Committee. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
Aye.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell, excused. Representative Hur.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
Aye.
Representative Liebling, excused. Representative Long.
Aye.
Representative Mortensen.
Aye.
Representative Novotny.
Aye.
Representative Farr.
Aye.
Representative Robbins.
Aye.
Representative Vang.
Aye.
Representative Zhang.
Aye.
Okay, that's 15 ayes and no nays.
The motion prevails, and House File 1287 as amended is recommended to be re-referred to the Committee on Human Services, Finance, and Policy. Thank you to our testifiers. Good job, everybody. We're now on the final bill. House File 1559 is a Representative Rasmusson bill. Representative Rasmusson, welcome to our committee. I will move that House File 1559 be recommended to be re-referred to the Health, Finance, and Policy Committee. We now have the bill before us, and I understand that you also have an author's amendment, which is the A2 amendment. That gets the bill in the shape that you would like. I will also then move the A2 author's amendment. All those in favor, please say aye.
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 Opposed? The motion prevails. The amendment is adopted. I think we're all a little tired of unmuting ourselves. I understand. Representative Rasmusson, your bill as amended is now before us. Please tell us about your bill.
Thank you, Madam Chair, for the opportunity to present House File 1559 today. This bill was brought to me by the Department of Human Services and the Minnesota Department of Health as a critical update to Minnesota's Safe Place for Newborns law. This bill has both agencies' full support, and I very much appreciate their hard work on this important issue. Enacted originally in 2000, the Safe Place for Newborns law allows a mother to safely and anonymously leave her unharmed newborn within 7 days of birth in a medical facility or to dial 911 to dispatch an ambulance for relinquishment. Medical staff will give shelter, healthcare, and aid to the newborn until transferred to the care of human services. This law is designed to help a mother protect her child when facing extraordinarily challenging circumstances. Simply put, this law saves lives and was passed in response to tragedies involving abandoned infants. I'm here today with House File 1559 to address a few serious problems with Minnesota's Safe Place for Newborns law. Currently, the law does not allow a mother to give birth in a hospital setting and use the Safe Place protections. Once a mother gives birth in a medical setting, anonymity cannot be maintained under our current law. DHS and MDH fear that this oversight discourages mothers from delivering babies safely in a medical setting, leaving them to deliver alone at home or in another non-medical setting. This bill continues the anonymity protection provided in the Safe Place statutes by creating a process delinking the mother's identity from her newborn
through birth records in those situations where a mother relinquishes her infant in a medical facility after giving birth. In addition, this bill also addresses important equity issues facing Native American infants who are afforded protections under the Indian Child Welfare Act and the Minnesota Indian Family Preservation Act. Currently, the law does not call for asking the mother if the newborn may have lineage to an Indian tribe, and if known, the name of the tribe. This bill explicitly allows safe places to ask for this information and report to DHS, helping to ensure Native American infants are given the protections and rights they deserve. Madam Chair, I have no testifiers today, but staff members from DHS and MDH are available to answer questions as needed.
All right, thank you for that good summary of the bill. Certainly a very important topic for us to address. As Representative Rasmusson noted, we've got a couple of folks from DHS here, but I think you did a great job of summarizing the bill. And as I noted earlier today, I trust my members to read their bills. So Representative Scott.
Thank you, Madam Chair, and thanks for hearing this bill. It's really important, and of course, we want these moms to deliver their babies in a safe place. And it's amazing that this bill was passed without the forethought of what this bill does. And so I'm thankful to Representative Rasmusson for bringing it forward, and for DHS for working hard on this and making sure that these babies come into the world as safely as they can. And these moms, they're already faced with a difficult choice of most likely, obviously, an unwanted pregnancy. And so I'm glad for this protection for both her and the baby. Thank you.
Thank you, Representative Scott. Members, any further discussion to this bill or questions? I will just say that Representative Rasmusson and to the DHS staff, I am grateful for the acknowledgement of how important it is that children be connected to their tribe, even if they are not being raised by their birth mother, and how important that is to have that information available to these children as they grow up. So I appreciate the recognition of the special status there. Representative Rasmusson, any final words on your bill?
Thank you, Madam Chair, for the opportunity to present the bill, and I appreciate your attention to this matter as well. And simply put, the aim of this bill is to protect the welfare of newborns in danger of abandonment, and also to help preserve the health and future of mothers who find themselves in incredibly challenging situations. So I appreciate the opportunity for the hearing today, and I would ask for member support.
All right, I will renew my motion that House File 1559 as amended be recommended to be referred to the Health, Finance, and Policy Committee. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
Aye.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell, excused. Representative Herr.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
Aye.
Representative Liebling, excused. Representative Long.
Aye.
Representative Mortensen.
Aye.
Representative Novotny.
Aye.
Representative Farr.
Aye.
Representative Robbins.
Aye.
Representative Fang.
Aye.
And Representative Zhang.
Aye.
There are 15 ayes and no nays.
The motion prevails, and House File 1559 as amended is on its way to the Health, Finance, and Policy Committee. Members, I was going to say that I should have scheduled more bills, but given our how well we were doing with unmuting and muting ourselves, I'm going to say that this is the best thing that could have happened this evening in a very busy first deadline week. So I thank everybody for their discussion today, and I promised Representative Frazier I would try to get us out of here to still catch that daylight. So members, we will meet at our regular time on Thursday morning, and then we're holding that 5 p.m. slot for what we don't finish. We're still awaiting the actual DE language for what we're hoping to, in House File 1404, which we heard last week, will function as a we'll have a DE amendment, and then we'll have what we're calling a data mini omnibus bill for some a handful of provisions that we previously heard to try to move those things along as they
Madam
there's
Chair.
no fiscal cost to those. Ms. Ganani.
The DE amendment was actually posted a little bit before the hearing started. So that is up on the committee page now.
All right. Well, thank you, Ms. Ganani. I was focused on my Zoom and not my email. So so take a look at that amendment, and we'll work on that on Thursday. Again, thank you, members. And with that, we are adjourned.